Greetings wherever you are. My name is Mathews Okoth. Welcome back to Corporate Law Channel. I took a small break. As many of you are aware, I was completing this book, Law of Corporate Finance in Kenya. The book is available. You can order it online at AML Publishers website, www.amlpublishers.co.ke. Now, Corporate Law Channel is a channel through which I discuss some of the topical corporate news items, particularly as carried in business daily newspapers, with a view to attempt to tease out some of the legal issues that arise from them, and just for greater context of understanding some of the corporate news. So the story that stood out for me in this episode, which is episode 11 of Corporate Law Channel, is at page 6 of the Business Daily newspaper. It's titled KCB Group Makes U-Turn on Full Buyout of DRC Bank. Now the gist of this story is that KCB Group started a process of acquiring equity in Congo's bank. The bank is called Congo's Trust Merchant Bank, TMB. It is reported that as at mid-December last year, that is December 2022, KCB had acquired 85% stake in TMB. Now there's the remaining 15% stake. There's a story of the decision by KCB not to acquire the remaining 15% stake, so that the bank can get its foothold in the market by benefiting from the experience of the founders of TMB. But that's not the core of our discussion today. What caught my attention is much as yes, KCB is not for now acquiring the remaining 15% stake, it has reserved its right of refusal, first right of refusal, in the event that the current shareholders holding that remaining 15% decide to sell. And so that forms the gist of our discussion today, a concept in company law called preemption right, the right of first refusal to buy whenever shares are being allotted by a company. Now, I discussed this issue on preemption rights and the general corporate law issues in chapter 19 of this book. If you look at chapter 19, it actually deals with some of the corporate law issues to consider when allotting shares, when the board is allotting shares. So one of them is what is called there the preemption right, but it's not the only one. There's primarily, first, there must be the authority by the board to allot the shares. And this authority can actually be granted in a number of ways. It can be granted in a meeting of shareholders during their annual general meeting. And that's provided for under Section 328 of the Companies Act. So if, say, a company has only one share, the shareholders meeting in an AGM can actually authorize a board to allot shares. The rationale for that authority is that, authority, whenever you allot shares, you are essentially bringing in either new shareholders or you are increasing the shareholding of the existing shareholders. And that, eventually it actually affects the claim on the assets of the business that remain the same. So there's an element of what is called value dilution by the existing shareholders, the assets of the business against which these shareholders take claim of profit remain the same. And that's why the shareholders have to be involved when you want to allot shares. All right. So one of the ways is by getting their resolution during an AGM. Now, if it is easy if there's only one class of shares. If there is more than one class of shares, then there is a two-stage process that have to be followed. The first one is, of course, to have the general body of shareholders vote to approve the allotment of the shares. And then there is a separate vote by what is called the affected class. If you read section 329 of the Companies Act, the affected class of shareholders have to also vote. I know lawyers can spend a whole day arguing what really is an affected class of shareholders that are entitled to separately vote and pass a special resolution before shares can be validly allotted. But all that has been answered in the book. It is actually there in their case law that I've discussed that try to at least reduce those incidences of conflicts, if at all they arise in a matter you're handling. Now, so one of the ways is, through authority, the direct authority to allot in an AGM. Alternatively, because at times it's very difficult to assemble all the shareholders every time you want to allot shares. Allotting shares enables the company to raise more capital. And at times this capital may be needed so quickly. So it takes time to bring shareholders together. So shareholders can delegate that power to allot shares to the board, either in the article itself or periodically, right? They can say maybe for the next 5 years, the shareholders will have the power to allot shares up to this extent. Or in the articles itself, the shareholders may decide to authorize the board to allot shares, again, of course, with an upper limit on how much shares these directors can allot, right? So that's the first corporate law issue. So that before we even talk of what is called the preemption right, the first right of refusal, we are talking of allotment of shares by a board of directors who we are saying must first have authority to allot the shares, right? Now, then when the authority exists, there is always that first refusal of existing shareholders. Still, speaking to the issue of, you are trying to protect existing shareholders from value dilution, right? So that you don't bash them with new members of the company who also stake claim on the profits of the business. Remember, we discussed in previous episodes that shareholders, particularly ordinary shareholders, they are residual risk bearers. They stand last in the queue, and the law is very deliberate to really protect their benefit out of the operations of the business by giving them control of decisions of the board that may affect, that may take away the opportunity for them to benefit from the profits, or at least reduce the extent to which they can benefit from the profits of the company. And one primary way through which the law intervenes is through what is called a preemption right. That is what KCB has reserved in this story item, which is carried in the Business Daily newspaper. That in the event that these shareholders who are holding 15% stake in TMB desire to sell their shares, the first right to sell will go to KCB. They must first be given a chance to refuse, right? Now, preemption right is provided under section 338 of the Companies Act. I've discussed that in chapter 19 of my book, right? And essentially, it applies, the law is very deliberate. It applies to holders of ordinary shareholders or rights that are convertible to ordinary shares. An ordinary shareholder, this I also have discussed before, is the typical residual risk bearer with full rights of control, but the very last in the queue when it comes to benefiting from the profits that the company distributes. So it is there is no automatic right of a return, but they have the right to everything else that is left, these ordinary shareholders, all right? So that they be rich in the queue of distribution, the law protects them that in the event that you want to limit the extent to which to what they can get by, you know, any incidence of, by increasing the number of stakeholders, you have to give them the first right to refuse to buy. And the period for the offer for them to refuse under law is 21 days. I'll discuss that also in the book. All right. Now, critical issues for lawyers, you know, the preemption rights applies if the consideration that the company that is issuing these shares receives is actually in cash. If you read section 342 of the Companies Act, it actually expressly talks of cash consideration. And I know lawyers have been very creative in coming up then with ways through which they can do what in law is called circumvention. They can circumvent that requirement that before the board allot shares to new shareholders, they must give, you know, opportunity to existing shareholders. And one of the strategies you can use if you are advising a company, like if you are advising these 15% or the board of TMB, assuming you want to deny KCB the preemption right, how do you circumvent that? If the consideration that TMB will receive is partly in cash or partly in kind, what section 342 of the Companies Act states is that preemption right applies if the consideration paid for the allotted shares is in cash. So if you issue shares in cash and in kind, you'll have circumvented the law. The other two structures I discussed in chapter 19, which are too complex for, I think they are more advanced for this video, called vendor placing and cash flow structures. Those ones you can get from the book itself. So there are ways in which the mere fact that a preemption right is reserved does not automatically mean that it will always be upheld. If you get a smart lawyer, they can circumvent, you know, those requirements so that the board gets to allot shares. Now, when we talk of, you know, giving a first right of refusal, it's very important to be clear on really the structure of how will you be doing it? You know, is it just a phone call to shareholders? How do you structure a preemption right, which I've also discussed. Primarily, it happens in two ways. One, through what is called a rights issue. A rights issue is an offer letter which is given to existing shareholders to exercise their right to buy these allotted shares. And crucially, it enables the existing shareholders to trade that right. At times, a company may give an offer at a price of new shares at a price that is lower than the market value of those shares. So these existing shareholders may feel that, well, I want to sell this right to third parties, particularly if this company is trading, right? So if the market value is higher than the offer given, then if the preemption right is structured as a rights issue, you have the right to sell it. You can sell it in the stock exchange, and it's a negotiable instrument, that offer, right? The other one is called an open offer. An open offer does not give the existing shareholders the right to sell, right? So so there are two ways, at least, that are known in law. But all of them are done through offer letters to existing shareholders, with the rider that in one is like a negotiable instrument. Negotiability means you can trade it. You can trade that right. All right. So that is episode 11. I believe it actually sheds light on this story in page 6 of today's Business Daily newspaper. So when you read the phrase there, KCB reserving its right of refusal, it's a preemption right? All that is in chapter 19 of this book. Thank you for listening to me, and bye-bye.